Well, thank you, Mr. Speaker, and I thank my colleague from Mississauga, Arundel, for his contribution this evening and for sharing his time with me. Mr. Speaker, I am pleased to participate in the second reading debate on Bill C-32, the Victims' Bill of Rights Act. Today, I will focus my remarks on the proposed remedies provisions of the Canadian Victim Bill of Rights. The Canadian Victims' Bill of Rights is aimed at ensuring that victims are treated with dignity and respect during the various stages of the criminal justice process and that their voices are in fact heard. Criminal justice professionals play a crucial role in the delivery of an effective criminal justice system. They do their jobs very well, often under very difficult circumstances, including dealing with victims with compassion and respect. But it does happen, and this is what victims told us, that they can feel that their rights have been breached or that they have been treated inappropriately. The Canadian Victims' Bill of Rights would ensure that there is a way to right a wrong when it happens. The Minister of Justice consulted with victims and other stakeholders across the country from April to October in 2013. Significant input was received, including in terms of options for a complaint resolution process. The Canadian Victims' Bill of Rights proposes a complaint resolution process that is based on the principle that the particular agency responsible for the breach should be the first to receive the complaint. Subsection 25(1) of the bill makes this very clear. Section 25 would also require all federal institutions involved in the criminal justice process to have mechanisms in place to receive complaints, to make recommendations for addressing any violations of rights, and to inform victims of the results of a complaint. This would include, for example, the Royal Canadian Mounted Police, the Public Prosecution Service of Canada, and the Corrections Service of Canada. Similar mechanisms are also in place in agencies that are under provincial and municipal responsibility, such as the Provincial Crown Prosecution Services and municipal police forces. Mr. Speaker, this approach has many benefits. It will help foster the sort of remedial responses that victims have indicated will be meaningful to them. During consultations with stakeholders and victims groups, many suggested that in response to a breach of a victim's rights, the agency responsible should issue an apology directly to the victim for the misconduct. They also indicated that the agency responsible should fix the problem so that it doesn't happen again to another victim. In other words, victims want remedies to include positive, responsive steps to change the culture or practices within an organization. They want remedies to be forward-looking and to address problems that have been detected. They want to spare other families from having to endure the same kind of mistreatment in the future. Victims are best served by sharing their concerns directly with the agencies that are tasked with protecting them, and by encouraging those agencies to see that every effort must be made to ensure that victims as an integral part of the criminal justice process, are treated with courtesy, compassion, and respect they deserve throughout every step of the process. Apologies and improved practices are key elements that each criminal justice agency must consider directly as part of their responsibilities toward victims and toward Canadians more generally. This approach also has the benefit that criminal justice agencies will treat remedies for a breach of victims' rights as part and parcel of their overarching obligations. It will also help keep costs manageable, as every such agency will already have in place a process for receiving complaints. Mr. Speaker, it is entirely possible that a victim who makes a complaint about the conduct of police or a prosecutor or a correctional institution may not be satisfied with the response they receive. Victims would therefore also be able to take their complaint to an authority that has jurisdiction over the agency that breached the right. Whether the agency is under federal or provincial authority, there are supervisory organizations that can take a fresh look at that complaint. In the case of a breach by a federal agency, if the complaint is not resolved to the satisfaction of the victim, the Federal Ombudsman for Victims of Crime would assist victims with complaints and work informally with relevant federal agencies to address the breach and improve practices for dealing with victims of crime. In regards to an allegation of infringement by a provincial or municipal agency, the bill respects the split constitutional jurisdiction and proposes that the applicable remedy is the remedy set out in the provincial law, policies, or practices. Provincially, remedial options may include ombudsmen for the province, specialized victims offices, or designated police oversight bodies, for instance. The Victims' Bill of Rights is the result of a balanced approach. Under this bill, victims of crime would not have standing to make complaints about breaches of their rights in court within the context of criminal proceedings against the accused. It is important to ensure that criminal trials are not sidetracked to deal with government agencies who allegedly have infringed the rights of victims. The criminal trial process must stay focused on determining the guilt or innocence of the person accused of a crime. State mistreatment of crime victims must be appropriately dealt with in its own right through separate processes. Mr. Speaker, I hope that all members of this House will join me in supporting this bill. We've heard tonight from a number of members on all sides of this House who support the bill and intend to vote in its favor. It will give victims a strong voice in the criminal justice system through the creation of rights for victims of crime and a strong remedial scheme to address breaches of those rights. Thank you, Mr. Speaker.
Questions and comments, questions et commentaires. L'honorable député de Sherbrooke.
Merci, Monsieur le Président. Je suis heureux de poser une question à mon collègue qui semble avoir bien à cœur le projet de loi C-32 sur les droits la Charte des droits des victimes. Mais si c'était si important, est-ce qu'il y a une explication? J'ai vraiment beaucoup de questions sur ce projet-là, mais je vais en poser une très brève et précise. Est-ce qu'il y a une explication qu'il pourrait fournir à la Chambre en ce qui a trait au temps que ça a pris entre la promesse de délivrer cette charte-là des droits des victimes qui avait été faite, si ma mémoire est bonne, depuis 2006, là, depuis l'élection que les conservateurs ont réussi à prendre le pouvoir. Est-ce qu'il y a une explication qui fait en sorte que ça a pris autant de temps avant qu'on en arrive finalement aujourd'hui avec le projet de loi C-32? Est-ce qu'il y a eu des blocages à certains points? Qu'est-ce qui explique tout le temps que ça a pris avant de pouvoir aboutir à ce projet de loi C-32?
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and I thank my colleague from Sherbrooke. Mr. Speaker, our government has been committed to finding resolution to crime and to fighting crime since we came to office in 2006. And the Canadian Victims' Bill of Rights is no different in our approach to finding resolution to issues that are of importance to Canadians. Clearly, we have been addressing crime and issues to reduce crime since we arrived in this government. And I would encourage, incidentally, that much of those crime bills that we have been so aggressively supporting throughout that time frame have regretfully been opposed by the opposition. This particular bill brings a different focus, a focus to addressing the needs of victims, and clearly, Mr. Speaker, I believe this bill addresses the issues that are necessary to be completed. Thank you.
The honourable member for Winnipeg North.
Mr. Speaker, the member didn't necessarily answer the question that was being posed, and I do believe it's a legitimate question. The Conservatives have talked for years about bringing in a Victims' Bill of Rights. In fact, they have made election platform issues on it. It was referenced to as long ago as the 2006 election. Now, I don't know if that is in fact factual. that if in fact it was a election platform issue in 2006. And so I would ask him, number one, was it an election platform issue for the Conservative Party back in 2006, to the best of his knowledge? And two, to provide some feedback as to why he believes specifically it has taken this long to get the bill brought forward, if in fact that is the case.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and I thank my colleague for the question. I can't answer with regards to 2006 specifically. I, in fact, did run in the election in 2006, and clearly creating safer streets and communities for Canadians was integral in that campaign. But as far as the Canadian Victims' Bill of Rights, let's just address some of the issues of what we have accomplished over the course of that time frame. We established the Office of the Federal Ombudsman for Victims of Crime. We created the Federal Victims Strategy with more than $120 million allocated since 2007 for programs and services that help victims, give them a more effective voice in the criminal justice system. Mr. Speaker, we allocated more than $10 million for new or enhanced child advocacy. We introduced legislation to double the victim surcharge and to make it mandatory, and we eliminated the so-called faint hope clause. Mr. Speaker, victims have been central and core to everything we have done since we've come to power, and I clearly believe this bill brings that focus to fruition. Thank you, Mr. Speaker.